Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are preparing for the Stephan Sterns trial coming up next week. Let's see. Jury selection starts on the 22nd, which is Tuesday. Currently, right now, it is Tuesday here. So next Tuesday, jury selection starts with opening statements slated for that Friday, which is the 25th. So this is supposed to be audio issues. Let's see. How's my audio? How's my audio, guys? Audio okay? Sound is hot.
It's really hot.
Audio issue? Oh, that's definitely hot. All right, hold on. Let me just back myself off a little. Didn't know my own strength there. Let me try that. I guess I got too much gain on, maybe? Mm-hmm. Let's see here.
Yeah.
All right. Okay, let's try that. Let's try that. Hello. Hello. Welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us. Let's try that. That definitely sounded a little hot. Let's try that. See what that sounds like. I'm the Squeegee of Justice. Thank you so much for joining us. All right, it's blasting and screeching. Yes, I had my overdrive on. I had my gain and my overdrive on. All right. So didn't know my own strength there. Definitely had the gain cranking. Well, we had to reboot yesterday, so when you reboot, all your settings go out the window. Sorry, I got cat hair in my mouse. So anyway, Stephan Sterns. This is supposed to be his last pretrial, right? So this is Tuesday. If you're watching live, this is Tuesday. Next Tuesday starts jury selection, and then that would be the 22nd. Then on the 25th, which is Friday, is going to be opening statements. So we're not sure if they're going to use all those 2 or 3 days to get a jury, or if they pick a jury on day one, if they'll start. Not quite sure. So just want to see who is with us. Let's see, who is with us? Brett, good morning to you. Alice Howell, Northwest, too early, not awake. Cindy Davidson, Psychosaurus Rex, and Kate. Oh, Sharon, nice. Candace Hoffman, Katie Cat, good to see you. Jamie Jane and David B, good to see you. Jeremiah Jordan, sound is not the best. Well, I think I fixed it. Well, I scrolled back too far. 13th juror, Billy Moore, how are you? Good to see you. Teresa, Aussie Gardner, One Sunny Day. June and Green Eyed Cat. Curviel, is Curviel with us? I didn't see Curviel come in. If you are here, Curviel, which I think you are, hello to you. Number one Cat Whisperer, good to see you. And Green Eyed Cat, thank you for the $3 donation. Happy Tuesday with your tacos. Appreciate that. Thank you so much for that. All right. Subaru, the sound is fixed. All right, cool. Yeah, I just had my gain too high. Like I said, we had to reboot yesterday, shut down the computers, did everything, and sometimes the settings get wonky. So anyway. Hey, Marie, how are you? Northwest says, Stearns has zero possible defense, just wants 2 weeks of listening to his photos being described. I have no idea what his defense is going to be. I have no idea. No idea. I mean... Hey, Selena K, how are you? Curviel is there. All right. There you are, Curviel, saying hello to everybody. Yeah. Nanny Goat, yes, I called the vet. I have an appointment next Thursday. They do a preliminary, and then I may have to take her back. See, with Rafa, I just went there, and they had time, and they just took him right in. This time they're saying that they have to do a preliminary research or preliminary exam, and then I may have to bring her back if they don't have time. I don't know. But anyway, I have an appointment for next Thursday, so that may have to get bumped because of Stearns. I don't know. We'll have to see. Hey, Gina, how are you? And Trish, Betsy Jean saying hello. Good morning to you. Number one Cat Whisperer, thank you for all your hard work, Trial TV. Thank you for that, number one Cat Whisperer. All right, so I'm looking out the door because Rafa's flopping around out there. He's got so much energy today. Let's see. Hey, Bice. Yep, he is cooked. Definitely cooked. All right, let's get to it because we got the ollies coming up in about an now I got to get going. Let's get going. All right, Stephan Sterns. Okay, so this was from yesterday, but the sound was terrible, right? The sound was really terrible. And so Aaron worked some magic. Hey, Golden Girl, good to see you. Kathy Swan, good morning. Lily Wayne, Polly versus Stearns. Hey, Stephen Rodriguez, good to see you. Joanne, Jedi Platypus. All right, Angelique, you love our cats' names. Thank you. All right, so let's get to it because we've got Ollie waiting for us in another hour or so. So this was yesterday. It's about 40 minutes or so. This is a pretrial. His sound was terrible. So Erin went through and she fixed it. So the sound is definitely much better. So let's check this out. Like I said, it's like 40 minutes or so. Yeah, 45 minutes. So here we go.
We're on 3 preliminary trial matters. Hearings are scheduled for 1 hour. Ms. Smith, I don't have a preference on what order we handle your motions. I'd like to address first. Pleasure. Mr. Johnson,
No problem. Taking on the first motion, Alex Johnson for the defense. We'd like to address defendant's motion to remove newspapers from courthouse during the proceedings.
all right, thank you.
As to argument for this motion, defense did have to be marked this morning, and I would move it into evidence as defense exhibit 1. It's been pre-marked as defense exhibit A, and a copy of the Osceola News Gazette that was present in the lobby this morning, which directly addresses the Stephan Sterns trial that began July 22nd. On the front page of the newspaper, Bolt.
State has no position here. Thanks. Have you received the defense 1 for purposes of this? Of course.
So as to this motion, with the recent valid motion to continue, the trial is set to begin next week in this courtroom. And as jurors, potential jurors and jurors that are selected in the trial walk into the courthouse, right in front of security or right beyond security is a slew of newspapers, including newspapers like the Osceola News Gazette, which every time we've had court appearance, Stephan Sterns has appeared on the front page of the newspaper. And the newspapers constantly indicate that there's both a sex case that is currently pending, which is what we're here for this morning, as well as a capital murder. So defense is requesting that just during the time that's the trial, not ongoing standing order going forward, that we remove these papers so that we're jurors are as they come in and go about the courthouse.
Understood. All right, the state takes a position. I have confirmed with jury services that jury services do not provide newspapers to potential jurors. The court always has to be careful balancing the right to free press and the right to open and fair jury trials. I do find that should there be newspapers available where the jurors can you give me some guidance as to where this table is downstairs? Is it over by the employee area? Is it where the general public would come in?
It's where the general public comes in. It's so if you're looking at the first floor, there's the area where you go to the elevators, and then there's the mirror there.
Yes.
It's the table's right in front of that.
I think I thought progress screens.
Yeah, exactly.
Correct. I have inquired as to our court administration who provides the newspapers. I think that's a county function. We have proactively reached out to the county to see if we can suspend the delivery of newspapers during the jury selection process and throughout the trial. So your motion is preliminarily granted. The court will direct parties that provide the newspapers not to do so during the jury selection or trial process.
Yes, good. Defense would next like to proceed on the defense's motion to order the all media to adhere to the rules of judicial administration and the administrative orders. Essentially, Judge, defense is asking, according to, as the rules require, that the media, and since defense is on the left side of this courtroom and the media is positioned directly behind us, their cameras, intentionally and inadvertently, I'm not saying that they're doing it intentionally, is focused on counsel's table in order to get views of Mr. Sterns and things of that nature. So in position, counsel's computer screens are in view of the media, so defense is requesting that the media not be allowed to look at, zoom in on, or otherwise project essentially onto counsel's table because of work product and attorney-client confidentiality. I understand that attorney-client confidentiality, we have to essentially affirmatively attempt to protect it. And when we have communications, we do mute the mic. However, because the table is so large, the spacing, the defense is just asking that the media not be ordered or not be allowed to zoom in on our computers or our computer screen. Under the administrative order, it says that communications between attorneys and their clients, between counsel and co-counsel, or anything that's held at then is required not to be recorded or broadcasted. So defense's position that anything that is occurring essentially at counsel's table in terms of notes, whether that be handwritten notes or computer screen notes, not being looked at. The defense has taken affirmative steps to have a privacy screen and additionally dimming the lighting on the laptops. However, even with that, it still is viewable for the media. And sitting in court to dim screens and dark nights for multiple hours is going to cause headaches, but also to protect not only Mr. Sterns' confidentiality, but potential other clients' information who we're working on while here in court. So that the media not be allowed to look at it, zoom in on computers or counsel's prior materials.
Generally, the state doesn't have a position. However, I think if the court is going to issue an order, it needs to be everybody in the courtroom, not just specifically media personnel.
I would say that the state as well, media personnel, anyone not you.
There's a lot of amateur media people that will cover this trial, and they use phones, from my experience in other high-profile trials. So the order should be broad enough that it covers everybody in the courtroom, perhaps even an order that people in the gallery should not be allowed to have their phones out during the trial. Yeah. Sometimes they need daily reminders. Sometimes they need multiple daily reminders, but they also focus on the state's computer, and we are obviously against that for the same reasons.
Understood. All right, our relationship with the media has been a good one. They're an essential community partner, and as I said, the court's going to strive to ensure that this is both an open trial and a fair trial. The days of passing notes back and forth are behind us. A little experience working with each of the attorneys, and here I know that your coordination with witnesses, with each other, with presentation, with evidence, highly computerized. The court will expect that the media will comply with Florida Rule of Judicial Administration 2.450, as well as our Administrative Order 2023-23. That order is fairly specific under subsection 2E, indicates that representatives may not cover sidebar bench conferences, no recordings of conferences or information that occurs between attorneys and their clients, between co-counsel, between the counsel and the presiding judge of the bench. I've done several trials where the media was involved. The only violations of 2.450 in our administrative order, in my opinion, have been inadvertent. Issues were when a camera operator perhaps went to a wide shot that included faces of the jurors during the trial, or there was a microphone that was inadvertently picking up communications through the microphones at counsel table after the microphones had been apparently muted by the attorneys. These are technical issues. We have a technical team here that the media is absolutely welcome to coordinate with. The administrative rule gives the media an opportunity to meet with our court administration if they have any questions about what the court's expectations will be. The court will expect that the media representatives will be credentialed pursuant to the rule. Non-credentialed members will not be permitted to have out cell phones as members of the general public. So I see no issue with the defense's request to have the media comply with the rules that are already in place. And the motion is granted. If representatives of the media have specific questions, they may contact my office. I will direct them to our administration personnel. We'll provide a copy of the administrative rule, which I'm sure they are most familiar, and judicial rule of judicial administration 2.4 So the court will expect that will be scrupulously followed in an effort not to impede the fairness of these proceedings.
The court restraints or normal
Thank you. State, you anticipate presenting any witnesses in support of restraints?
The state just has one.
All right. I'm in.
Deputy Richard Rosario.
Thank you.
You solemnly swear or that you can't without
Hello.
Morning, will you spell your first and last name for the record?
Yes, Ricardo, Ricardo. Last name is Rosario, Rosario.
How long have you been employed as a court deputy?
Since March of 2017.
And is your primary assignment to this courtroom that we're actually in right?
Yes.
Are there policies in place for the use of any type of restraints during a felony criminal trial for an accused?
That's correct.
And how many felony criminal trials have you participated in as a court deputy?
You know, it's countless. I can't remember how many.
That's fair.
Work.
What type of devices or restraints are available that would be out of the view of members of the jury?
So each courtroom has two. One device is kept downstairs on the first floor, which is a stun cuff, and in the courtrooms we have a leg brace.
How is a leg brace utilized by court deputies during the pendency of a criminal trial?
So a leg brace is essentially a long bar. It has 4 straps, and in the center there's a tab that you can pull so the person can sit down. Otherwise, the bar won't bend. So basically, what happens is when the person sits, it bends, but when they stand up, it just locks, and it prevents the person to run away. They would have to essentially hop away because that leg is stiff.
What is the purpose? Let me ask you this. Are there any safety concerns for you as a court deputy in this courtroom should a accused during the criminal trial not be equipped with such a thing as a leg brace?
That's correct. So when any inmate is brought over to the courthouse, they're in restraints, handcuffs, and leg chains. When they're brought over for a trial, they are dressed out in proper attire, suit, and at that point, they're in the custody of the sheriff's office, and we have to maintain a level of safety and security for the inmate and as well for everybody else in the courtroom. So that's the reason why we utilize those restraints.
Is there limited staff here at the courthouse for the sheriff's office?
Yeah, so in a perfect day, the felony courtrooms will have 3 deputies. A misdemeanor courtroom would have 2, and civil would have 1. But due to staffing, sometimes people take off or they're sick, and there's it creates a safety hazard if we're running a high-profile felony case with just 2 deputies. So hence the reason why we use also the device.
Is this device something that is visible to anybody that is looking at the outer appearance of an inmate that's wearing it?
No.
Is this device something that delivers a shock or pulse of electricity or anything like that?
That's correct.
It does or it does not?
It does.
It does. When does that happen?
So, if I may, I have the device in front of me.
Would utilizing the device assist you in explaining how it operates?
Yes, ma'am.
Go ahead.
So, essentially, this is a stun cuff that's wrapped around a inmate's ankle and is tucked away under the clothing. There are 2 metal pieces here that close to the subject's skin, and the strap is placed accordingly and wrapped not tightly but snug that it won't fall off. The remote is this right here, which is kept at all times with a deputy within the courtroom. Nobody knows who has it. It's hidden discreetly. No one sees it. To activate this cuff, it's a 2-step process. There's on, and then there's fire. So the device won't accidentally fire on itself. It has to have 2-step button to fire the device.
And the device isn't triggered by movements of an individual or anything like that either?
That's correct.
And is this something that is utilized by court staff in addition to the leg brace that you described?
It's one or the other.
Okay. So there's 2 options that are potentially available to court deputies depending on the scenario.
Correct.
And both of these options are outside the view of anybody that is looking at the outer appearance of an individual as long as they're wearing pants.
Correct. So when we put these devices on, inmate that's scheduled for trial, it's out of the view of the public. It's out of the view of the jurors. No one knows that the person set for trial has it on.
And let's talk a little bit about writing utensils. If there's an inmate present in court, are they given a writing utensil?
Yes, they do. They get a flexible pen.
And those flexible pens are made available by court staff to individuals that are participating in the criminal trial process.
Yeah.
And what is the purpose of court deputies providing that specific type of writing utensil?
Essentially, the pen, it does write well, but is used sort of for a safety purpose in the event that the inmate would like to use it sort of as a weapon. The pen is designed to fold and flex, as opposed to another pen or a big pen or a metal pen that can actually be used as a more deadly device.
It's a safety concern for court deputies?
Yes.
Can I just have a minute?
Of course.
For the purposes of this trial next week, what is the type of restraint that court staff deemed as appropriate for this?
We will be utilizing the stun cuff, and actually this is a newer version. The older version is a much bigger broader box. This one is a newer one. So we'll be using this one right here.
Thank you. Defense?
Good morning, deputies.
Good morning.
Now, you talked about the number of deputy or court personnel typically kind of staffing the courtroom. Are you aware of what arrangements, if any, have been made in terms of staffing for this trial?
None yet.
So you don't know how many deputies potentially would be or won't be in the courtroom?
That's a question above my pay grade, so I just won't have to figure that one out.
Understood. Now, you talked about two different devices, and you indicated the stun cuff is the intention in this case, correct?
Yes, ma'am.
And is that because that's generally what's used in this courtroom, or because of what?
99.99% of the time, we always use a stun.
So I'm going to talk a little bit about the leg brace, since you did talk about that. Now, this leg brace, this is a longer device. Like it's not as small as the stun cuff, correct?
Right. It's essentially a metal bar. It's pretty long and it has 4 straps.
And to your knowledge, is that comfortable or uncomfortable?
I would say rather a bit more cumbersome because it's strapped alongside the leg of the person, and if they stretch their leg, it'll snap shut.
So essentially, normal movements could cause it to lock up.
Yeah, as soon as the person stands up, it will lock.
And then the stun cuff, I know you talked about this being a smaller apparatus that goes typically closer to the ankle, correct?
Correct.
And depending on the type of pants or clothing that is worn by the person, that could affect the visibility of the item.
Yes. So normally male inmates will always have long pants, and the cuffs go right around it, so you really can't see it.
But the pants legs would have to be wide enough to kind of flow and fall over so it wouldn't be visible, correct?
Yes, we always apply to the right leg, which is furthest away from the jurors.
And typically when sitting down, your pants often rise, generally speaking, correct?
Yes.
And so if the pants are shorter, then the stun cuff at that point would be visible likely?
Possibly.
And those straps, I know we saw kind of like the strap that goes around. Where does the extra, so to speak, of that tuck in, or does it tuck in somewhere?
So when you apply this apparatus, it wraps around and then the strap goes through here so it holds it down.
Okay. So similar to a belt, you know how when you use a belt and you have the extra, where would you tuck in, or where does that extra strap go?
It just remains there and just folds in.
So would it be secured, or would it be kind of sticking out?
Just stick it out right. I mean, you would really have to look for it to find it.
Okay. Now, you talked about the 2-step process with that remote for the stun cuff. I believe you said it was an on and a fire, correct? So does that mean that once the stun cuff is applied, it's typically automatically in that on position, and then you just have to go to step 2 or something else?
Well, the apparatus is turned on, so it's always going to be on. But to fire it, you have to press the on button again and then press fire.
Okay. And those 2 buttons are, I don't want to assume, are they next to each other on the remote, or are they 2 different areas of the remote?
Yeah, so the on, and then you would have to switch over to fire.
So one side is on and one side is fire. And I believe you said that typically one deputy has it. Maybe between the 3 of you or 2 of you, depending on how many are in here, you guys would know, but none of the other court personnel.
Who has it?
Just the person who has it, I assume.
Yes.
So you would know that you don't have it, and so if it's only 2 of you, by a process of elimination, the other person would have it.
Correct. So essentially, when we do a courtroom operation, each deputy has an assignment. One is for the inmate, one is for jurors and one is for security of everybody.
Now let's talk about the writing utensil. You talked about this flex pen or the flexi pen, about how it's designed to collapse in on itself. Now this pen still does have a normal point, like that a ballpoint pen would have, correct?
Right.
Would the utilization of, say, a felt pen be something that could potentially not be a safety measure?
Well, we're not really concerned about the tip of the pen. We're concerned more of the body of the pen. A more firm structure to be used as a stabbing type weapon.
Uh-huh. And with, are you familiar with felt pens? Okay. Now with those, typically that point, it's soft, correct?
Yes.
And with the flexi pens, and even with the stun cuff, those are only utilized for people who are in custody, correct?
Correct.
If an inmate who wasn't in custody was sitting at counsel table, he wouldn't have to have on, or she would not have to have on a stun cuff or a leg brace, correct?
Correct.
And writing utensil, if a person was out of custody, they also would not have to use a flexi pen, correct?
We normally give them flex as well.
Even a person who's out of custody?
Yes.
In terms of, I know you talked a lot about safety. Are you aware of any attempted escapes or anything like that for Mr. Sterns?
Of Mr. Sterns or any other inmate?
Mr. Sterns specifically?
No.
Can I have a moment, Judge? Have you had any defendants complain about the comfort of the stun cuff or the leg brace?
No. So essentially, if the stun cuffs, we put it that's too tight, so it doesn't impede with blood flow or anything, or potentially injury. But it is placed snug, so this way it won't slip out. So, but we've not had complaints.
So no one's ever complained about like itching or discomfort or rubbing?
No.
What about with the leg brace?
I've not had much use of the leg brace. So the leg brace, to be clear, is if the courthouse has a number of jury trials of that day, and these stun cuffs are placed in the chargers respectively downstairs in our office, and whoever gets it first just grabs them, then we just have to go to the leg brace because there's no more stun cuffs.
Okay. And do you know any stun cuffs the sheriff's office has in terms of within the courthouse?
Well, I believe we have 4.
And I know you mentioned staffing and things like that haven't been addressed yet, so you're not necessarily sure of the logistics of what potential other trials might be needing them?
So normally with big high-profile cases, there's a meeting with the judge, court, jury services, and sometimes our supervisors will be there just for logistics.
Okay. But I believe you had said that at this point, you're not sure if it's happened or you weren't a party to it.
Exactly. But I have no knowledge of it.
Then one more moment, Judge.
Cool.
And I know you mentioned not being aware of like escape attempts or anything like that. Are you aware of any violent outbursts or any propensity for violence that Mr. Sterns has demonstrated during the course of his incarceration?
No, he's been quite compliant with everything we tell him to do, as far as just remain seated and come this way and sit down. He's not giving us a problem yet.
No further questions, Judge.
That's correct.
Okay.
Yeah, it was already. Yeah. Thank you, Deb. Additional witness rebels.
No, yeah.
Thank you. Defense argument.
Yes, Judge. Defense in this case is asking that Mr. Sterns be free of full time idle use of the leg brace or the stun cuff, and we're also asking for the use of a regular light utensil. So pen in this case.
Why? Why do you care what writing intentionally is?
Judge, in prior experience, the flexi pens, they often skip, they often don't have ink, or they don't write well. So when a time is to communicate, especially in an attempt to not use the microphone so that counsel can pay attention to the questions that are being asked, having a utensil that writes and functions easily and freely as opposed to having to stop, well, not necessarily stop the proceedings, but trying to get a deputy's attention to get us another flex pen while we're also trying to watch what is being presented, listen for objections or making necessary objections. Essentially, it's a distraction if we're having to make sure that his pen is working and he's able to communicate with us, or being able to read it if it's skipping. So we're trying to figure out essentially what are the holes in the bubbles of what he's writing. Generally speaking, the flexi pen in the past haven't been the best. And I understand, kind of like regular, if you grab one out of the box, if it works good, it works good. So we're asking for like a belt tip, and I understand the deputy's testimony in terms of the safety concern. It's the defense's position that use of a felt tip pen, being as a soft tip, it's essentially a marker. We'll give it to him without the cap, would be sufficient. He would be able to write and communicate with us easily and effortlessly without having to worry about pen stopping or not working and things of that nature. So we're asking for the use of a regular writing utensil with a courtroom felt tip pen to utilize. And then in terms of the restraints, again, we're asking for Mr. Sterns to be free of the restraint. I understand the policy of the sheriff's office and things of that nature. However, it's looking at a case-by-case basis, not a general policy that applies across the board. There's no testimony of any escape attempts, any offensive violence during the course of incarceration. However, the deputy actually testified to the opposite. They exercise compliance. If he listens, follows direction, does what it gets to class. So, and I understand the staffing issue. However, at this point, they're not aware of the number of deputies that will or won't be in the courtroom anyways. So it's asking that Mr. Sterns be free of physical restraints. Because if he was out of custody in this case, he would not have physical restraints. I know the deputy testified that typically people who are out of custody also use flex pens. That hasn't generally been my experience in this courtroom, but that could have changed since the last time I've done a trial here in this courtroom. The defense is asking that Mr. Sterns be free of physical restraints and utilize rarely reminders.
Thank you, Mr.
Yes, Your Honor, the state provided testimony through Deputy Rosario, who testified as to what type of restraint would be used for this trial should the court deny the motion, the process of utilizing that stun cuff. Also, he testified as to any potential safety concerns with this being a felony criminal trial, and also any safety concern with the type of writing provided. State would request that the court deny the defense's motion.
Thanks. Can I see one of the safety? Do we have one? All right, purposes of the record, holding one of the safety pens, they basically the internal tube that has the ink in it, and it's surrounded by a clear rubber tube, fairly flexible. They're also about 3 inches long. And what essentially different than the writing instruments that the attorneys would be using. All right, we're not on the capital motion. We're not in uncharted territory. There's case law that applies to this case. Weaver v. State 8947 178. That's a Supreme Court case from 2004. In that case, there was a defendant that was charged with serious crime. In the appeal, they took issue with the electronic restraining device, a belt in that case. In that case, the defense cited United States v. Durham. That's 287 Federal 3rd, 1297, 11th Circuit 2002 case. In that case, the 11th Circuit indicated that a stun belt poses a greater threat to the dignity of the courtroom than shackles. That was based on a potential that it was reasonable to assume that much of a defendant's focus and attention when wearing a stud belt was occupied by anxiety over a possible trigger of the belt. Interestingly, in that case, there was an accidental discharge of the stun belt that occurred outside of the presence of the jury. Florida Supreme Court in that case found that the judge's discretion in exercising of the discretion to wear a stun belt was warranted. However, in that case, the defendant was pro se and was permitted freedom of movement about the courtroom. So, court in the Weaver case surmised that there was no lesser alternatives other than stun belt to allow freedom of movement, as well as accomplishing the concerns, which was a concern regarding escape or proximity to the attorneys, the jury, court. In this case, we do have an alternative. The court has never had an accidental discharge of the stun cuff. The court has not before had any indications that the stun cuff was visible to the jury. The court before it's never been presented with the argument that a defendant was preoccupied by the wearing of the stun cuff. But in this case, Mr. Sterns will not have freedom of movement in the courtroom. The use of the leg brace, the court as well has never received a complaint about the comfort of a leg brace. Because Mr. Sterns will not have freedom of movement, the court's heard no prejudice to the fair trial proceeding to have Mr. Sterns wear a leg brace that would, in the unlikely event that may not be compliant and stand up and make an effort to exit the courtroom, that would lock and give the resources that are on hand an opportunity to intervene. The court understands that these matters should be considered on a case-by-case basis. The court can see no prejudice. The device will not be visible. The court has not before received a complaint about the comfort of that particular device, and the fact that Mr. Sterns will not be permitted to move about the courtroom anyway. The court can't find that would be prejudicial, and the court finds that a consideration of due to the layout of this courtroom, proximity to the jury, proximity to the exit of the courtroom, and the severity of the allegations and the emotional nature of the what is surely to be presented, that a leg brace is warranted, will be ordered to be implemented while he is present in the courtroom. We also have a private area that can be outfitted, and I'll address continuing concerns with. That is going to conclude our hearing. Use of the pen. He'll be provided with a felt pen. I'm going to ask that that be specific to Mr. Sterns. That will remain in the courtroom. When he comes and goes, he can have the flex pen in the back if he needs to write notes while we are not present in front of the jury. The court understands the concerns of the deputies, and I sympathize with that. The layout or the construction of the flex pen, it's different than the construction of ordinary pens. I fear that it may create a question in the mind of the jury as to his incarcerative status. That would be prejudicial. So he'll be provided with a felt pen, and he'll just leave it on the table. Any further?
Just a logistical matter, Your Honor. We are intending to bring a whiteboard TV for the presentation of evidence next week. Mm-hmm. So as to protect as much as we can the sensitive nature of the material that we must show to the jury. So logistically, I just wanted to bring it to the court and defense's attention.
Will this be on a cart?
Yes. It's on wheels.
So what do you need from me? Place to put it?
We can bring it up when we are intending to use it. I just wanted the court to know, because I know sometimes the court is going to need to get to view the evidence. I anticipate that we'll put it over closer to the jury so that the family, who is also essentially going to be present, will not have view of it. Also, other individuals will.
Yes, I understand it. Evidence is obviously of a sensitive nature and is unlawful in and of itself. I am happy to provide the courtroom on the afternoon of the 21st if you want to wheel your equipment up or have your tech folks do so. Gameplay how you would like to present that. The attorneys will obviously have an opportunity to move about the courtroom as they need to observe evidence. Mr. Sterns also has a right to view the evidence being considered against him. So we're going to have to accommodate all of those competing interests to ensure that the jury has an opportunity to review the evidence that the state intends to present. Does the state intend to close the courtroom or request a closure of the courtroom during the presentation of any testimony or evidence?
Your Honor, that is the intention of utilizing the whiteboards, that only individuals that have to view the content. We do not have a surviving victim to testify in this case, so I don't know that we necessarily have a right to close the courtroom for any of the proceedings. However, due to the sensitive nature of the material that is going to be presented in the form of actual videos and photos and things, the state intends to utilize the whiteboard in an effort to prevent other individuals that do not need to see that evidence.
Anticipated some of the evidence was multimedia, and I didn't know whether it had sound or what this was going to be.
There are, I believe, 5 counts that are video with sound.
If the state makes a determination that closure of the courtroom is warranted pursuant to statute and victim rights, Marcy's law, I'll ask that's your intention. You present that in writing, and we'll address that. Give the defense an opportunity to weigh in on that request.
Yes, sure.
Thank you. Vince.
I believe that was, those are all.
Thank you. But as I said, the court will make itself available for the rest of this week and on Monday for access to the courtroom. If you have specialized concerns, equipment concerns, please be proactive in asking in advance and resolving those issues with court staff prior to jury selection beginning on Tuesday, the 22nd. That'll conclude our hearing. Thank you. Emily, you got some stuff there?
Yes, Judge, you can provide this.
So we'll run those screen bin and let's just take a look.
Color perfect.
To you guys.
Yeah, I was going to put it back here.
I need to know what this is and what's talking.
All right, so that concludes that happened yesterday. Aaron fixed the audio. So we did that for you guys. I've got an echo going on. Hold on just a second. Let's see if that fixed it. I feel like I've got an echo going on here somewhere. Hold on. I don't have anything else open. That's muted. That's muted. All right. I'll just roll with it. All right, so basically that was him arguing about, restraints. Leg brace or ankle stun strap. Judge ultimately went with the ankle stun strap. Then, of course, defense requested for him to be out of restraints. And then she was talking about the writing utensils. And the judge is like, why do you care? Why do you care about the writing utensils? She's like, well, they don't always function. You may have to stop the proceedings. It may be a distraction. Sure. But ultimately, judge went with a felt pen and a stun ankle. Then the state talked about a whiteboard. Was talking about a whiteboard to show sensitive, obviously and a TV. Obviously, very, very sensitive material is going to be going on here. Hold on, let me make myself bigger. Talk about little man in the corner there. All right, so yeah, it was talking about a whiteboard and a TV for evidence presentation. Obviously, very, very sensitive information. So they said 5 counts. There's going to be 5 counts that they're going to show a video. So then, and it's all in an effort so that those who shouldn't see it don't see it, right? So, and they also talked about the media in the courtroom. Sorry, that was at the beginning of it. Oh, sorry, at the very, very beginning was these newspapers. Apparently there's a table with a bunch of newspapers. So the motion was granted that the newspapers won't be on the table during jury selection. What about during the trial? That doesn't make sense. So you're gonna pick the jury, but then you're gonna let them see all these newspapers during the trial? I don't get that. But anyway, hey, what's up, Zach? Good to see you. Just in time for the squeak cap. Let's see. So let's see. So newspapers. Okay, newspapers will be off the table during jury selection. Media in the courtroom. Defense requests media not to be allowed to zoom in onto the table. Absolutely, no, they shouldn't. State said, hey, if court issues an order for them, it should be everyone. And then Mr. J from Sarah Boone, William J, got up and says, well, there's going to be a lot of amateurs covering this in the gallery, so they shouldn't have their phones. Are we amateur? Are we amateur, Mr. J? I told you that our chat liked your tie. I said, our chat likes your tie. And he was just like, yeah. I did like his socks. He had cool socks on today. All right, so then we talked about the ankle bracelets. All right, guys. So let's see. Ankle bracelet, ankle stun thing's going to pop up. Felt tip. Oh, whiteboard. All right. So that pretty much does that. All right. You can see when I pull up the featured chat, you see what happens there. We got to sort that out. So clearly we have to sort that out. All right. So let me. Does it happen over here too? So it doesn't happen there. It just happens here. And it doesn't happen there. All right, so you see how that, when I pull up featured chat, it comes up. So, all right, so we got to fix that. All right, guys. Mary, you just walked in. And Joyce, good to see you. All right, hey, guys, we're going to end it here. I'm going to call it a day here for Stephan Sterns. The 22nd jury selection starts, and then opening statements no later than the 25th. So that's Tuesday to Friday. So if they pick a jury, maybe Wednesday or Thursday. We might be starting a little bit early. I'm not sure. But in any event, we're going to be covering it. Jules will be joining us. Jules is going to co-host this. Instead of Jules being there, which she really, really wants to be there, and I did too. I wanted to go down there. Maybe it's the September one. We might go to that one. But we just couldn't swing this one. Anyway, Jules will be co-hosting with us. She'll be sitting side by side with me. We'll be talking about, be doing breaks, recaps, all that fun stuff. So yes, now we go over to Ali. Here, let me pull that up. Lily Wayne, yes. So we're going over to the Ali's, Washington versus Ali. That starts in about 15 minutes. Actually starts at the top of the hour at noon, our time, 9 o'clock West Coast. So I am going to say goodbye here. Aaron has a redirect on, so we're all set up there. Thank you to our mods. Thank you to Aaron for putting together this audio. She spent time on it yesterday and last night, fixed the audio. Oh, there's Rafa. There's little Rafa. Hi, little bee. Hi. All right, I should go let him out. All right, guys, thank you for joining us. Thank you, chat. Hey, we're at 11,000. You guys, we were at 10,900 or something, so we made it to 11,000 subs. So thank you for that, guys. Thank you for the new people that joined us. And we are going to go over to Washington versus Ali. I'll see you guys there in about 15 minutes. But thanks for now. Thank you for joining us, and we'll see you in a little bit. Bye.